The responsibilities of the Office of State's Attorney. The State's Attorney is elected to a 4-year term in a non-presidential election year. The Office of State's Attorney for Cecil County is primarily responsible for the investigation, prosecution of criminal cases at the trial level, and works with police and development of cases, presentations to the grand jury, trials in case of district and circuit court or juvenile court. The State's Attorney's Office initiates its own program of services with focus on specific crime issues. Also helps with victims and witness concerns. It also partners with other local and state agencies to promote the health and safety of the Cecil County citizens. With that, we'll start at Deputy Frank.
I'm going to stand up because when I was sitting in the back, I couldn't see the people speaking up front, the judges speaking up front. Again, my name is Carl Fockler. I'm the Deputy State's Attorney for Cecil County. I have been practicing in Cecil County now since 1993. I've been a prosecutor on 2 stints. Actually, I've operated under 4 or 5 administrations at this point in time. But John Scarborough had hired me back in 1998-99 after I had run against John as a Republican. I suppose I was around 30 years old or so. Shortly after the election, after he had hired me, I worked there through the Eastridge administration. I subsequently resigned in about 2005, I believe, during the Eastridge administration. At that point in time, I did district court work and circuit court work as well. And then, of course, I went back to the private practice. And then again, in about 2013-14, I was hired again under the reign of Judge Ellis, or Mr. Ellis Rollins. And again, after Ellis Rollins left office, again under the administration of Stephen Cecil, our current interim state's attorney. The state's attorney, I just want to say, it really is a privilege and it's an honor to be running for this office. Many of you don't know the state's attorney's office is the state's attorney is the highest law enforcement officer in the county because the state's attorney takes in the cases that are brought to them by law enforcement, all the different administrations, state police, the county sheriff's department, local municipalities, and we go ahead and prosecute those cases. Some cases are prosecuted, some cases are not prosecuted. It is a high burden to carry being the state's attorney, and it is an incredibly important role where it takes incredible discretion, judgment, and common sense, quite frankly. And on top of that, it's administrative as well. The office itself, in deciding, it's not just prosecuting every case, it's also deciding what cases to prosecute and also what cases not to prosecute, which are of great importance in this particular office. Since I've been Deputy State's Attorney and since we've had the change in administration, our office is evolving. It's constantly evolving right now. We have a tremendous amount of volume which is coming into the State's Attorney's office, and we're doing the work, and we're getting it done, and we're taking cases and evaluating cases and prosecuting cases, but quite frankly, our office needs to do better. Unfortunately, we've been somewhat in a state of limbo for the last year while we're waiting for this election process to occur, but even though we haven't made any major changes, changes are still happening. For example, we have we've changed it, the whole court system has changed. MDEC came into process in which we've gone from paper into electronic. The State's Attorney's Office has had to bring in and conduct its own in-filing system with Carpel. We've also have had the influx of body cameras which are coming in from the Elkton Police Department and other agencies, Rising Sun, Perryville. We are having additional greater pressures on the office. And when all these cameras comes in, and if an event happens, you may have 6 or 7 different officers that have body cameras going through it, and that's a tremendous amount of data in which to complete. We need, of course, to handle that particular information. and we're in the process of doing that. We've instituted access to Axum, which is getting access into EPD's body cameras, and also Perryville as well, in Northeast. We're also using technology to help institute file sharing, for example, with the law enforcement officials. And we are in the process of, which is RMS, which is a record management system. We're in the process of coordinating so that the state's attorney's office can help gather that information more efficiently, because we have had issues in the past with this tremendous crush of information that we have to go through and sort out and then press out to the defense counsel. We have to go ahead and grow so that we can handle it. I want to say this, that our office has handled in the past about 1,700 cases, okay, in 2017. You compare that to Harford County, which has handled about 1,800, and I'm talking about jury prayers and indictments that come through the circuit court, okay? They're very much equivalent or comparable in the amount of volume that we do. That's not including a lot of other cases of juveniles and whatnot. But our staff that we have at the state's attorney office, we have approximately 11 staff attorneys and 11 personnel. So we've got about 22 staff. We compare that to Harford County, who again has about 100 more cases in volume. They have essentially 27 attorneys and 32 staff. Our budget at our state's attorney's office is about $2 million a year. Their budget is close to $6 million a year. So my point is this: we need to demand and we need to expect the best that we can have in our state's attorney's office. Our state's attorney's office is good, and let me say, our staff, the limited staff that we have, they do a great job, but we need to do better. And collectively, our county, we need more resources so that we can do these things. How else are we going to do this? I would help to, or start to institute a homicide task force. We need to have, because when we get these cases and they come in, we need greater control over the cases before they get charged. We need to make sure that our cases are tighter, smarter, more effective, and more efficient. And how do we do that? We communicate with other law enforcement and we bring them in before we institute large charges on some of these serious murder cases and whatnot. We need to make sure that ship is buttoned up tight. And in the past, quite frankly, it hasn't been. We've done a great job at getting convictions in murder cases, but in going forward, we need to be smarter, and more intelligent, and more efficient. And we do have good communication with law enforcement, but it does need to be improved and it needs to be better. Like I said, the state's attorney's office, when it comes to the end of the day, is what cases go forward and what cases don't go forward, is the commander of the ship. And we need to make sure that those cases are tight before they go forward. Well, thank you very much.
Good evening. My name's Amanda Bestics. I just want to thank the Republican Club for putting together tonight's event. I want to thank everyone for coming out tonight to hear from us and to ask questions. I decided to run after a lot of thought and consideration, but ultimately for me it came down to the fact that I believe our community deserves strong leadership and someone who is committed to the office and protecting our community. I know with my leadership skills, determination, and commitment to protecting and serving our community that I'm the best person for the job. I believe fighting crime and protecting the community is a collaborative effort, that we all play a role, and together we can create a community that criminals are afraid to commit crime. My vision for the office is quite simple. I want an office that effectively and efficiently prosecutes cases, holds defendants accountable for their crimes, and is accountable and transparent to the public. There is a lot of work that needs to be done, but I'm committed to taking on this task and strengthening the office. As the next state's attorney, I pledge to fight for tougher sentences for drug distributors, violent offenders, subsequent offenders, and offenders preying upon our children. These are the individuals that present the biggest danger to our community. I will ensure that our priority is on protecting the victims and the community and not on protecting the defendant. I will mandate that at all bail hearings for these offenders that we are requesting no bail. To me, they are the epitome of a danger to the community, and we will advocate for these individuals to remain jailed pending trial. The ultimate goal, of course, will be to hold defendants accountable for their actions, and I will hold prosecutors accountable for their inaction. I will require approval, and I will be reviewing all null process, stats, and all felony cases that will be pled down to misdemeanors. There will be a checks and balances system in the office. The goal is to ensure that prosecutors are holding, again, defendants accountable for crimes and putting victims and the community first. I will also increase victim advocacy. And let me first say that we have two wonderful victim witness coordinators in our office. I've spent countless hours with these ladies, speaking with families and preparing with victims. And they are dedicated to the office, to the community, and to the victims. It has been my policy since joining the State's Attorney's Office to speak with each and every victim in my cases. I make sure that they understand the proceedings and that we discuss all possible outcomes with a case. I will not and do not resolve a case without victim input. It is important that each and every prosecutor in the office is zealously advocating and communicating with victims. Nothing short of this will be acceptable. It is our job to fight for justice for victims and to protect the community from any further harm. We will also strengthen our collaboration and communication with law enforcement. Law enforcement is the backbone of the State's Attorney's Office, and I will expect every prosecutor to initiate and maintain communication with law enforcement from the beginning of a case to the end of a case. I will also ensure that there's more community involvement. I've found while campaigning that some don't even realize what the State's Attorney's Office does. I will hold Ask the State's Attorney's forums, much like Sheriff Adams. I had the opportunity to attend one, and I found it to be a great opportunity to ask questions and be informed, and I believe that this will be beneficial to the community. The State's Attorney's Office is a public office. We should be and will be transparent and accountable to the public. Lastly, we must work towards having an office with full-time prosecutors. We currently have approximately 13 prosecutors in the office, over half of which are part-time. Our office has remained stagnant through the years while law enforcement has grown, the population has grown, and the increase in our caseload has dramatically increased. The necessity for full-time prosecutors is imperative now. I will work towards making the part-time positions in the office full-time because this is what our community deserves and needs. In order to move forward and strengthen the State's Attorney's Office, changes are necessary. I am committed to making these changes and believe together we can work towards a safer Cecil County. Thank you.
I'm not going to need a microphone tonight. It is an honor and a privilege to be here. I know it was presented to you as a question and answer period, but most respectfully, we know what the questions are, we know what the issues are. I'm going to talk about solutions. As your state's attorney, I'm going to hit the ground running. I have two initiatives I'm going to implement immediately. Do you hear people talking about the plight of the elderly? Too often, our seniors are subject to physical abuse, emotional abuse, financial theft, neglect, things of that sort. I will advocate for our elderly. I will bring together police, prosecutors, social workers, first responders, doctors, people who care for and are used to protecting the elderly. The second thing I would do is confront the drug trade directly. Drug addiction is the chief affliction of our fellow citizens. And I repeat that. They are our fellow citizens. They're somebody's son, somebody's granddaughter, somebody's spouse, and sadly, far too often, somebody's grandparent. We need to identify effective treatment programs and find out how to select the one that's best for the addict. I will bring together people for consultations, such as Jack Foraker from Haven House, April Foster from Steps Recovery. These are enthusiastic people with experience who know what they're doing and can help us. But secondly, I'm going to change the policy of the state's attorney's office in dealing with felony narcotics cases. I'm going to assign one assistant to the drug task force for the purpose of working with them from the initiation of an investigation through the questions of charging and then through prosecution. I will assign a second one to the non-task force felony drug cases. That person will be responsible for screening out those cases that warrant vigorous prosecution and more serious sentences. Both assistants will be charged with identifying the felons who are eligible for enhanced or mandatory penalties and seeking them. I have labored in the arena of the courts for 30 years. I have seen the inefficiencies. I have recognized the deadwood that's within the system. I have listened to literally thousands of victims, and I've heard the frustration of people who have to deal with the courts. These are not easy issues to address. I could be slowing down. I could be preparing for retirement. I could be taking it easy. I am not going to do that. I am not through working. I will continue to work so that we can cross the bridge and create an enterprise of hope for the people of Cecil County.
Thank you very much, I appreciate it. Let me reiterate, these are not my questions. Thank God,
Have any other questions?
thank God you're not the one cutting off judges and attorneys. Starting at the far end of the table, these are some specific questions, and I'll go to the more broad questions. Do you recall the Barry petition case? How do you respond to the complaints by the community and law enforcement about the handling of this case and the plea offer?
I didn't hear the question, I'm sorry.
Sorry, Carl. Do you recall the Barry petition case?
Very petty on case.
Yes, sir. That's it.
I do.
I'm sorry. How do you respond to the complaints by the community and law enforcement about the handling of this case and the plea offer that was given to them?
Well, Barry Pettion was charged, from my recollection, with a possession with intent to distribute case located in the area of Hollingsworth Manor. Obviously, cases that come before the state's attorney's office, every case is different. Quite frankly, very seldom is any case perfect. And this is something that we need to concentrate on again before the indictment process, to making sure that all the labs are in, all the reports are in, all the body cams are in, making sure that we have all of this information so that we can go ahead and effectively prosecute cases. But in this case with Mr. Barry Pettion, who I believe pled guilty to a handgun as well as to possession of heroin, is my recollection. Many times also cases are, when it comes down to it, you may contact our experts in the area of the task force in regards to quantity. And sometimes the quantity is borderline, quite frankly. Sometimes there's not always the indicia. You may have a certain number of bags of heroin, but there may not be, for example, if you only had maybe 10 bags of heroin, somebody can still get charged with possession with intent to distribute, though quite frankly, it may only be truly a possession case. What may turn it into a possession with intent to distribute case is in regards to what other indicia is there. Are there cell phone records? Is there a scale? Are there glassine baggies? Is there money that was gathered or seized at the time to create that possession with intent to distribute case? But quite frankly, in the Barry Petillon case, we happen to have issues with the investigating officer who was part of that case was unavailable for trial on the day of trial. Unbeknownst, and that happens, unfortunately, that happens from time to time. The officer knew about the trial and did not post up for trial. So there you are, which happens from time to time. A lot of people don't like to think that may happen, but it does happen. So what do you do at that point in time? You better be gosh darn quick on your feet, because you've got a jury that's going to be coming in. You're going to be required to go to trial, and you may get absolutely nothing. So you need to be quick on your feet, be willing to make a deal, and make it happen so that you can lock that person down. Sometimes you don't have a tight enough case, and sometimes you may have to give a little bit, but oftentimes, you know, in those situations, you want, quite frankly, I want to make sure that that person is going to be accountable. Okay, in that situation, I was in a tough situation with Mr. Barry Petillon, but I made a plea. I got the plea to the drugs. I got the plea to the handgun. Quite frankly, with what I had, I think it was a darn good plea. It's tough, but my point is this: is that Barry Petillon's on probation now. I don't know if it's for 3 or 5 years. In all these cases, I recommend 5 years, because I want this guy to be accountable to me, because I don't want him dealing any more drugs. I don't want him having any guns. And if he does, I'm going to yank that chain, and I'm going to put him on a violation of probation. He's going to be back in jail. So that's the way I look at a lot of these cases when we find ourselves in those unfortunate situations. But it happens. But like I said, you better be quick and you better be smart when that does happen.
Thank you. Superintendent Bessick. For those who are not well versed with the court system, there's a common misconception and a negative connotation associated with plea deals. Can you explain plea deals, how they work, and how they're used frequently in most specifically criminal cases?
Yes. So plea deals are sort of a necessary factor. We have a case, and we have to, we're usually not, the large majority of cases do not go to trial. Our plea deal rate is, I believe, around 90-some percentage in the circuit court. For me, though, a plea deal is supposed to accomplish a few things, and that is deterrence, protecting the community, and seeking justice for victims. You do have, as Carl was sort of describing, oftentimes with cases, the state's attorney's office is handed a case, and we have to deal with what we're given. And unlike defense attorneys, where they can come up with a bunch of different avenues and different stories for cases, we are stuck with what we have. And so there are times where we have evidentiary issues, we have witness issues, and we try to do the best we can to resolve the case and keep those factors in place, you know, punishing the defendant, protecting the community, and justice for the victims. What I guess I've noticed is that sometimes it seems like we're pleading good cases, and that's not acceptable to me. We should be, again, ensuring that we're protecting the community with our pleas, and that's why I want to review any steps, any null crosses, reductions from felonies to misdemeanors, because that's how, number one, we have the checks and balances, and we ensure that that's not going to happen in the future.
Kevin Urick, this question is to ask for a response to the Wendy Culberson accusations, was to say she let her emotions overrule the realities of the law. Is that your position when dealing with difficult victims, to disregard their feelings?
Can you repeat the last half of that?
Sure, I'll do it again. The response to Wendy Culberson's accusations was to say she let her emotions overrule the realities of the law. And the question is that your position when dealing with difficult victims, to disregard their feelings?
Everyone deals with difficult people. Difficult victims, difficult witnesses, difficult police. I think the best response to what Ms. Culbertson said, well, it would be a personal expense. Let me introduce Angela Dowd. If you'd stand up, Ms. Dowd. She is my deputy campaign manager. She was in a domestic violence marriage for 20 years. If you want the opinion of someone who's experienced with domestic violence and how I view it and how seriously I take it, ask her. She will be glad to talk to anyone in here tonight. Let me give you some statistics. For the last 3 years, I have been hired by the Domestic Violence Shelter to represent female victims in domestic violence protective order hearings. In my civil practice, where I do divorce work, I would say about 10% of my female clients are victims of domestic violence, and the overtones and the advice goes along with handling those cases. For 10 years, I was the child abuse prosecutor here in Cecil County. If there's any sort of vile domestic violence, it's abuse against children by relatives. For 10 years, I handled that. I dealt with every victim in every case. And I think if you talk to the people who I represented, whose cases I handled, I think you're going to hear overwhelmingly positive things about me. But also, talk to the 10 or 20 people who are still serving sentences in this county because I prosecuted them. They will tell you, I definitely took what they did seriously.
Thank you, Kevin. This is an interesting question posed. This is for E.B. and Carl. Do you support the Elders campaign? If so, how will you deal with the conflict if both of you win?
There we go. Certainly I support my brother. Absolutely. I think you make a fine judge. But the more important question is what you're asking is that in the event, I suppose, that we were both elected. You know, we've been practicing now in this particular county for quite some time. And what it is we have a wall that's set up between the two of us. Neither of us, you know, he's on the public defender side, I'm on the prosecutor's side. We keep a wall up between us. We're never handling cases against the other. And in the event that it'd be the same thing. If he were a judge and I was the state's attorney, it'd be the same way. I wouldn't be prosecuting cases in front of him, and he wouldn't be hearing my cases. Now, it's interesting that if I'm the head of the agency, the state's attorney, there certainly could be perceived an issue in that regard because everybody is underneath me. But I would like to say that that issue was somewhat approached with the Ellis Rollins when he was the administrator of the state's attorney's office. And he had 2 boys who were prosecuting. And I do believe that a opinion was requested of the Attorney General's office, in which the Attorney General's, and I haven't seen this letter personally because I kind of question it myself, but apparently the Attorney General's office gave the blessing for that all to proceed, and I would say that that is akin to the situation which could possibly occur in the event both of us were elected. So we have 3 other judges in the circuit court. We've been working in this court system, both of us being criminal prosecutors and/or defenders for the last 5 or 6 years, and it has not been an issue. So I don't foresee it being a problem. There's enough judges and there are enough attorneys to handle it out, and I think, quite frankly, the AG's office doesn't have a problem with it either.
And I'd say it would be a non-issue too, because we're very careful about it, and as officers of the court that we're required to uphold the law and make sure any perceived conflicts are noted by clients or, I guess, victims in Carl's case. And it's funny because people do occasionally get us mixed up. I don't know. I have actually had troopers call me, asking to speak to Mr. Fockler, and started talking about a case, and I said, "You want me? I think you want Carl." Like, oh. So, and of course, as a judge, I'm required to be above reproach and unbiased, and there would be no hint of that. So that would not be permitted. I was vetted too. My name was sent to the governor, along with Mr. Davis, for both district and circuit court. He got tapped, I didn't, and Judge Campbell got tapped, and I didn't. So, but I was right there with him, and that, your name doesn't get to that point without your integrity intact. So I'll leave it at that. Thank you.
For Amanda Bessex, if someone has a suspended sentence or on probation, why is it that the defendant isn't required to then serve their suspended sentence?
That's actually a good question, and it's one that I'm not going to be able to give a good answer, because really that comes down to our job is to make recommendations to the court. Once we make those recommendations, it's sort of then on the judge to decide what to do. I know it's our position with those suspended sentences where they come back, it's on a violation of probation. Our position, more often than not, is to ask for the balance of any suspended sentence. And that's really all we can try to continue to do, is ask for those suspended sentences. We just need the judges to then give those sentences that we're requesting.
Kevin Eric, what do you identify as the #1 concern for the state attorney's office in the next 4 years?
There are two. The first I'll address because it really goes to the heart of what we do, which is criminal prosecution. We are now heavily into an era where there's a dominant theory of rehabilitation and treatment. It is handicapping. It's basically putting handcuffs on our ability when we identify someone who needs to be taken out of society to protect society to be able to do that. We're fighting a battle right now to try to get mandatory sentences back, some of the mandatories that they have removed. I will be in Annapolis working with the State's Attorneys Association, arguing for that. We need the ability, when we've identified someone who's truly a danger, to put them away to protect society. The second is a more internal thing. It's probably not so interesting to the general public, but it's adopting to the technology. We're going to a paperless office. We're dealing with filing electronically. Sounds great, but it is incredibly time consuming. It takes far longer to sit down at a computer, boot the computer up, bring up a website, put in a password, and then spend 10 minutes being able to file a single sheet of paper. We used to be able to print out the paper, put it in the mail, and it's gone. Incredibly time consuming. We need more manpower. Our staff are overworked. When I see how hard the secretaries are working, we think we work hard. They are working twice as hard because they're doing everything that's the clerical work, which is time consuming. We've got to do a more efficient job, and we have to advocate with the council, with the state, for more money so that we can get the manpower that we need right now to be able to do this work more efficiently.
Back to the other side of the table, Mr. Carl Crawford. If there's one flaw in the Cecil County judicial system that you would like to rectify, what would it be?
In regards to prosecution, I think one of the biggest issues that we have right now is our discovery issues, and the ability to get the discovery out in a timely and efficient manner. We have the court, which is under tremendous pressures to push these cases forward. And if many of you don't know, we have what's called a Hicks date. It's your due process right to a speedy trial. And the courts right now are very much targeted on that. And it's my understanding that many times the docket management that the court has to follow is hinged or tied to perhaps grant monies that come in and perhaps support things like drug court or that kind of thing. So the courts are very, very focused, as they should be, on the time management of these particular cases. But unfortunately, at times it can be the tail wagging the dog, so to speak. The courts are so concentrated, focused on that, that they're very rigid and are, in my opinion, quite frankly, arbitrary in providing reasonable time or granting postponements in which to accommodate certain discovery issues. But postponement should be granted, again, on a good cause basis. And that good cause is not, it's not a super high threshold, but quite frankly, with the courts, it's become a very, very high threshold. And that, quite frankly, hurts prosecution, it hurts public safety, and it's grossly unfortunate. And quite frankly, I don't think it's serving the public. But the courts, we've had discussions with the courts because we are trying to accommodate that. We've had, the current state's attorney and myself have met with the chief administrative law judge, and what we have done at this point in time is we've double stacked cases, which has created a tremendous burden on our particular office because our attorneys are handling essentially twice the caseload than they ordinarily would, and we're trying to get the numbers down so when that first trial date comes up, it's not backed right up to that Hicks date, so that it's maybe 60 days prior to. So that in the event we need a postponement for whatever particular purpose, we have time to get it back in before that 180-day period elapses. Because guess what, folks? Once that 180-day period passes, the case has to be dismissed, unless it's been continued for good cause or for whatever particular reason. But other than that, it's a dead set date. It's a big hindrance for us. We'd like to, again, it's about communications with the court and getting the court to be a little bit more manageable, but the state's attorney's office needs to take that role and to go out there and push for reasonable, common sense administration of the court system, and also the prosecution.
Thanks, Carl. Amanda Messick, can you elaborate on the discovery phase? I think probably lost most of us at that point.
So discovery, we are required per the Maryland rules to provide discovery in each and every criminal case, district court, and as well as the circuit court. District court, actually, there are separate discovery rules for district court and for circuit court. In the district court, I believe the rules state that defense has to request it. In the circuit court, however, we are required to provide it regardless of whether it's requested or not. And so discovery consists of just think of it as any evidence we plan to present at trial. So if we're using videos, if we're using photos, if we're using interviews, all of that has to be provided to the defense counsel, or if it's a defendant that's pro se, we're required to give it to the defendant himself. We also, pursuant to the rules, are required to continue discovery as more information comes in. Oftentimes, we don't have all of the discovery at the time a case is indicted, so we're required to continue to provide discovery throughout the life of the case as we get information in. Discovery also includes if we're going to call experts. Each and every part of the discovery rule, there's a little subsection, and it covers all the various documents that you could be using at trial. So essentially, though, think of discovery as all of the evidence that we're going to use at trial.
Thank you, Wilson. Thanks. So, Kevin, on that subject with discovery, and how do you weave that in with, how do you feel about victim communication and input on cases?
The whole case is based on victims when it's a person's crime. Without the victim telling us what happened, we wouldn't have a case 90% of the time. In a homicide, there may be other evidence, so we don't need the victim, but victims are the case. They have to be interviewed by the police, they have to be interviewed by the prosecutors. Without that, you can't successfully prosecute a case. That's the lifeblood for against a person's crime is the victim.
Coming back down to the other side of the table, please. Appreciate it. Carl Faulkner. Do you see a way to stop having defendants from taking a plea deal on the day of trial, which in turn costs a great deal of money because each juror is paid?
So the question is whether or not I see a way of stopping that. The answer to that is no. Defendants never want to plead guilty. Okay, they don't want to plead guilty till it's that drop dead last minute, because who knows what may happen. An officer may not show up, a witness may not show up. There may be a fire drill or a bomb thrown. I mean, who knows what may happen. So defendants don't like to plead guilty, and also they don't like to go to jail. So it's the nature of the beast that we are always going to have guilty pleas on the day of trial. The courts certainly don't like it, and we understand that. I mean, it's part economics, right? I mean, because we pay jurors $20 a pop when they come on in, and so it does cost. It does cost money. But what can we do as the state's attorney's office to try to avoid that? We have shifted. The courts instituted a policy where we have pre-trial conferences about sometimes the day before trial or a couple of days before trial. The victim's required to come in, and hopefully at that point in time, very much like the civil settlement conference, perhaps we can work out the case. Sometimes we can, sometimes we can't. It's going to happen. But the courts, and the courts sometimes get upset about it, and sometimes they get really upset about it. And I'm quite frankly disappointed when they do, because they were all attorneys as well, and they understand that things don't always go as the courts desire them to do. People don't always plead guilty at a pretrial conference, and it's just the way it's going to be. So do I see that ever being necessarily curtailed? No, I really don't.
Amanda, as a candidate for state's attorney, do you think you can manage other businesses and properties and be able to fully commit to this position? I understand from someone that this is actually a pay cut for most attorneys.
Yeah, people don't become prosecutors to get rich. Thank you. But what I've learned, I actually am one of the part-time prosecutors, and what I've learned since being promoted to the circuit court, and since as of January I began, I guess, as the lead prosecutor of the sex crimes and child abuse unit, what I've learned is part-time doesn't cut it. I am in the office every single day because that's what my cases require, that's what my victims, deserve. So as far as, to me personally, no, I don't believe that I could have businesses and other properties and focus solely on the state's attorney's office, which is what I think the state's attorney should be doing, is focusing solely on the office. However, that's also a question for the voters, and if that's a concern for them. So, thank you.
Thank you. And lastly, I think we'll, Kevin, would you support or oppose having a full-time prosecution staff? Please give the reasons.
I want more people. I don't care if they're part-time or full-time. We need bodies to do work.
I think I speak for most when I say that public safety is the number one issue here, and everywhere, of course. In Cecil County, we see the crime and drugs and pervasive things that go on. Most people see this as a small town, Cecil County, small town area, but these big city crimes are going on. So starting with Carl Faulkner, just wrap it up if you would and tell us the plans for the future.
I will answer just briefly the full-time question, because I know that's a big issue for the county and the administration and so forth. And it is important. I mean, as Deputy State's Attorney, it's correct. It's a full-time job. It is not a part-time job. And I believe that if I were State's Attorney, I mean, the hiring would be for full-time prosecutors. You need full-time prosecutors in there. These cases have lives of their own, and they really require the due diligence so that we can do a better job of prosecuting and preparation and getting discovery. And guess what? If we don't have discovery, you're getting on the horn and you're knocking on that door or bringing the phone of that officer or that agency to say, hey, we need this discovery. You need to get it in. And that takes time. It takes time to interview and speak with witnesses. So full-time is certainly the way to go. Now, I'll agree with what Kevin said to a certain degree, and that is, I don't want to be handcuffed, though, to having to hire full-time state's attorneys. It would be my intent to hire all full-time, but for example, if I needed a part-time person to maybe do forfeiture proceedings, which is an area in which we really need to concentrate on, or should be concentrating on, there's lots of money in forfeiture that are just sitting there that we need to go ahead and file the proceedings in order to acquire this information or these monies so that they can be released. But for something in that particular area, or someone to do, most of you may not know of, like post-convictions. It's another area where you never hear about, but defendants have time. The case may end, right? We may get a verdict or a plea, but that case continues, and it's a real struggle for victims, because even though they may have to come back, they do the trial, they may have to come back for the sentencing, and then they got to come back for a violation of probation, or maybe they come back for a motion for trial, or then they come back for a motion for post-conviction. I mean, victims get pulled and pulled, and this may be years and years after the case is passed. But there may be avenues for where part-time work may be appropriate, and I don't think that the state's attorney, who is the person in charge of the office, should be handcuffed to just a full-time or part-time. But primarily for new hirings going forward, I would certainly be going full-time and looking to shift people into the full-time position. And I will say that we've had 2 new hires here as of recently, James Delmeyer and Cameron Brown, who both are part-time folks, but I would hire those 2 all over again. And if they were required to go full-time, chances are they wouldn't have come on board. So there are times when it does make sense. I also want to say is that I am very excited about the future of the state's attorney's office. This office is going to improve. It is going to get better. We are going to become more effective, more efficient. We're going to be working closer with the community and certainly with law enforcement, but also with the health department, participating in the other groups like the drug-free Cecil and so forth, because it is not only in the prosecution, which we need to do, and we need to do effectively, and we need to be stern and be asking for strong sentences that are meaningful. But beyond that, we also need to be leading in our communities and in the war against the drugs and so forth, so that we can make a safer, more secure, and healthier Cecil County. Is that my last time that I'll be talking?
I was not hoping, but I was.
I
I was hoping this would be the closing remarks.
This is the closing remark. I just also want to say thank you so much for coming out and participating and listening. And we greatly appreciate it. It's important what's happening up here, and I also think it's great that we have 3 people who are running for office, because everybody deserves to have an opportunity to select an individual. So again, thank you for the opportunity.
I just briefly want to address the full-time question really quickly before I give my closing remarks. I think I take a much tougher stance on the full-time issue because, again, I am a part-timer. And I just see the urgency for full-time. I don't feel as the state's attorney, I can go to the county council and I can say to the county council, hey, give me more bodies. Meanwhile, I have part-timers that to me should be full-timers. So I think we need to make those part-timers full-timers before I can go to the county council and say, hey, I need additional bodies. I think we have to start first in the office with the resources we have and then move to asking for more bodies if that's what's needed. To wrap things up, I'm not going to go back into sort of what I want to do. You guys heard it in my opening remarks, but for me, it all comes down to we need major changes in the office. The continuing theme is we need accountability, we need transparency, we need effective and efficient prosecution in the office. If you're not happy with the way things are, well, let me change that. If you're happy with the way things are going in the office right now, I'm not the candidate for you. If you're looking for changes, as I am looking for changes, then I'm asking for your support on June 26th. Because I do want to strengthen the office. I want to make the office better because that is what the community deserves. Again, thank you for everyone coming out tonight. Thank you to Mr. Faulkner, Mr. York, and I appreciate hearing all the input and the questions from everyone.
Well, let me start off by thanking my wife, May Urick. You may know her as May Urick, for all the support she gives me. Let me tell you the difference between being a U.S. assistant U.S. attorney and an assistant state's attorney. Federal prosecutors are discretionary. They can pick and choose what they take to prosecute. They have no obligation to prosecute any specific crime. What this means is a police officer goes to the assistant U.S. attorney, and the U.S. attorney says, any publicity in this case? The police officer said, yeah, it's all over the news, they're crying for blood. The assistant says, what's your evidence? We've got 10 eyewitnesses. Any other evidence? Well, it was on videotape, security camera. Anything else? We have fingerprints. Was there anything else? Well, there was DNA evidence. Is that all? Well, we have a 10-page signed confession from the defendant, too. The assistant says, I'll take that one. The police officer comes back a few days later, says, I have a case. The assistant U.S. attorney says, well, get any publicity? Yeah, it's all over the news. People are crying for blood. Well, what's your evidence? Well, there was an eyewitness. The assistant says there's some problem. He said, well, the person has disappeared, but we think ultimately we'll be able to find her. Is there anything else? Not really. The assistant says, okay, let's give this to the state's attorney. We have to prosecute crimes in the state. It's obligatory. We don't have the discretion to pick and choose the good cases and only prosecute them. We have to take everything, from the strongest to the weakest that comes in through the process. I'll admit, there have been a few times I've thought it would have been so much nicer to be an assistant U.S. attorney. That lasts about 30 seconds, and I think, you know, without a challenge, it wouldn't be worthwhile. I've had 30 years of challenges, and I've loved every minute of it. Do you succeed at everyone? No. Do you fail at everyone? No. But if you enjoy challenges, and you're able to survive the rough and tumble nature of courtroom proceedings, every time there's a trial, somebody wins, somebody loses. We're the only profession that loses half the time. Well, come to think of it, that'd be pretty good in baseball. That'd be 500. So maybe baseball has it worse than a lawyer. But you have to develop the ability to roll with the punches. And it's not until you've been punched and knocked to the ground numerous times, and it takes years, if not decades, to reach that point, that you really become proficient at your task, that you become able to handle it and be an effective prosecutor. Thank you.
Thank you so much.